SJC 13345, Commonwealth v. Cheyenne, F. Velasquez.
Okay, Attorney Semmel, whenever you're ready.
Good morning, may it please the court. I'm Catherine Semmel on behalf of the Commonwealth. This case comes before the court on a reported question from an appeals court single justice. It's a matter of statutory interpretation, determining essentially when the clock starts to run for the 90-day period of pretrial detention allowed under Section 58B. And I would suggest the Lynn District Court got it right when they dated that 90-day period from the order of revocation that was issued.
Nothing to do with anything, but I'm not really, it wasn't very pleasant to read that the clerk made the decision and not the judge.
I do believe that the clerk had a very clear understanding of what the rule was. Never having been a trial judge myself, I can't comment on that perhaps as much as you, Justice Lowy, but I think that's probably what the clerks do every day.
Right. No, counsel. This is Justice Seifert. Can you hear me?
Yes.
Yes.
Okay. Let me just following up on Justice Lowy's question, though, with regard to the clerk making the decision and not the judge. Certainly, judges rely on clerks and clerks rely on judges. That's just normal. However, what in this case would be the authority for the clerk saying that? And I know you've got a series of arguments in your briefs that work together and you follow them and you get to your result. But if you just could explain it in one sentence, what's the reason that you want your date rather than the date? Why do you want arraignment rather than the date the person's being held, starts being held?
Well, I
Or
think,
why do you want the bail revocation date, rather?
I think that the purpose is to effectuate the legislative intent. In this case, I think the legislative intent was that the 90 days starts from the date of revocation.
And that's based on what?
And that's based on the use of the word subsection.
So, okay, all right.
And I think that if you think of it in the inverse, the one thing that this court has recognized that different words have different meanings, and when the legislature uses different words within the same statute, they mean different things. You can't use them interchangeably. You have to understand each in relation to each other. So I think the one thing that sentence, that last sentence of 58B cannot mean is that it encompasses the entirety of 58B, because that would just be
Why not? I mean,
Right.
what are the subsections of 58B?
there are no subsections of 58B.
Exactly, so the word is nonsensical. Whereas you look at 58A, when it uses the word subsection, it actually refers to subsection 1, subsection 4. Here we have a word that refers to something that doesn't exist.
That is, I think that is absolutely true. If we were to surmise, it was perhaps devised in 58A and transferred to 58B without enough thought about defining
So
what
let's
subsection
assume
meant.
that we agree that that's probably right. What's the right answer then? Why is it from the date of the hearing as opposed to arraignment?
I think that by negative inference, the legislature did not mean the entirety of 58B.
All right. So what I'm hearing is that the only way we can come to your answer is through working through the subsection statutory analysis. That there's no simple way to look at that, or you have to walk through those arguments, right?
I think that's true. I mean, certainly once you have walked through those arguments, I think when you look at and which this court has done in other instances, absent the problem of there being no subsections, but it has worked through the analysis of what section means and what subsection means in other cases.
What's your closest, I think you're going there. What are the cases are you relying on that have a scenario where the legislature has used the word subsection, but there isn't a subsection in the statute?
I don't think, I don't have any analogy there. I think probably the justice was heading toward that result. I don't have that, but I do have cases which are cited, like Milliken and Hines, where they say section means the whole section. And that's the common understanding. That's in the title, it's section 58B. And it's clear that it's used in this way in section 58B by the legislature. So perhaps it's an inverse inference that when they say subsection, they mean something different. And certainly the court has conducted that kind of analysis, said that if they say X here and say Y here, then Y is different than X.
Counsel, can I ask a different question? Why is the Commonwealth fighting this fight? Because I don't understand, and please help me understand it, because if we're talking about the detention here, why should the Commonwealth, in construction of this statute, why should that inure to the detriment of the defendant in this dead time?
So I think and I would like to answer your question, I would like to clarify in my answer to Justice Lowaite that I did not mean that clerks are always making determinations instead of judges, but I meant that they are always making determinations of time. Just like to make clear about that. Justice Georges, I think that in this case, I did a survey of my office. I saw the position of the clerk. I saw the position of the judge. Clearly, courts in the Commonwealth have, and the statute has been around in this part of it since 1994. Courts of the Commonwealth have interpreted the statute this way. Have interpreted the statute.
Counsel, are you saying then that throughout the Commonwealth, we have judges and clerks who are counting the 90 days from the date of the revocation, even if a defendant has been held
I'd push back on
3
you
days,
on that.
That's allowed in certain circumstances. So, like, they could be held a month. They could be arraigned, and for whatever reason, this gets put off for 30 days. That 30 days wouldn't count?
It's only when there's an alternate means of detention, correct?
When what?
Yeah. Yes, I think that's true. So in some circumstances, that's true, but not in all circumstances. And I think in response to Justice Georges, clearly it's not across the board, because we see in this case, when Middlesex docketed the case, they went back to the date of arraignment. I'm not saying that there is a conclusive and across-the-board consensus. If there were, perhaps this court need not weigh in on it, but as it is, we very much want the court to weigh in on it.
So how we get here procedurally, though, if I can go back to what, I mean, we're talking about 58B in this instance, but what predicated this was the dangerousness finding. So is it the Commonwealth's view that if we were calculating this date of detention under 58A, and at arraignment, the Commonwealth moved for it, and the defense wanted their extension, and it was 7 days until we had a 58A hearing, that upon the finding of dangerousness that the court could not credit the time of detention from the time the Commonwealth moved for detention in calculating the detention period?
That's my understanding, Your Honor, and I would say
So
I think it's
again, I
clear
go back to, we know the parade of horribles that happens when people get detained. They lose jobs. They lose. They may not be able to make their appointments. All of these things happen when we take people out. We always talk about reentry upon the conclusion of custodial sentences, but no one talks about what happens when you're just detained on bail, on detention periods. Why does this make sense that the legislature would have said, if you get detained at arraignment when the Commonwealth moves for this, that we don't get to calculate that? Now, I have a slightly different question for you. Is your construction of 58B, does that preclude the judge from running it non-pro-tunc?
I'm sorry, I'm not
Does
sure.
that, if you're saying that that essentially a defendant has to sit there with dead time, And this is what the legislature intended when they enacted this, that you are going to have situations where people are just going to sit there and not get any credit for being detained and being incarcerated. That the judge, upon looking at that, saying, I don't think that's fair, and I'm going to run it non-pro-tunc to the date of arraignment.
I don't think that what happens with regard to the 90 to the 120 days impacts what happens later if the individual is sentenced.
I don't understand your answer there. Can you expand on that?
I'm sorry? Oh,
I
could
said I didn't understand your answer to Justice George's. Can you expand on that?
I think that the issue of dead time is a separate issue, which occurs at sentencing and is not part of.
No. Dead time is dead time. That is you sitting in jail and getting no credit, whether it's the imposition of a custodial sentence or because you've been detained because the Commonwealth have moved with dangerousness or a revocation period. Dead time is dead time. And it's important to not just discuss this as if it doesn't really matter that people are sitting in jail. And that's a big deal to me. So the question I have is, if the Commonwealth were to have this, if we were to say you're right, does that necessarily mean that we're also telling the judges that you can't run this non-pro-tunc?
No, I don't think we're telling the judges that. And I think with regard to what the legislature did is they set a time that you could be held after a hearing. That's my interpretation. And they set a very constrained time period in which you could be held prior to that hearing. And I do think that that's the way the legislature set it up. And I do think that it's within the purview of the legislature to do that. And unless the court feels it's not within the purview of the legislature to make that determination, then I do think that it is important to ascertain if the court believes that that was in fact the legislative intent. And I would suggest that the linguistic evidence suggests that it was. And that to so find is certainly consistent with the overall goals of public safety, which are clearly attached to 58A and 58B both.
Yeah, I'm sorry to interrupt again. This is Justice Cipher again. Can I ask you, please, on that Justice George's question with regard to non-pro-tunc? What about that answer you just gave would prevent a judge from redating the order?
I'm sorry, I didn't hear the end.
What would prevent, in the answer you just gave, what is it that prevents a judge from doing this non-pro-tunc?
But right or wrong, your answer is the statute.
My answer is a statute.
So,
Thanks, Justice Lowey.
Thank you.
well, I don't know if you're gonna thank me after this question. You better hold your thank you for a second. So, the judge got this visceral reaction to this situation that goes right to what Justice George is saying. It's like, geez, can't we do this? I mean, and the reason he sort of says, can't we do this, is because you got a provision, 58B, that allows for a revocation here, and it's tied in many ways for excludable delay to Rule 36. And you got a rising out of, I understand a rising out of this subsection. There's no subsection, so you think it must mean a rising out of a revocation situation. And why isn't the judge's sort of visceral reaction right, that the legislature did want to have the preventative detention under these circumstances if the judge exercises his or her discretion on a preventative detention after an offense or after conditions violated. But they also want to limit it, for all the reasons that Justice George has talked about, to 90 days minus excludable delay. And if there happens to be a snowstorm, and you go from February 2nd to February 8th, that defendant has to do more than the legislature said. Not 90 days minus excludable delay, but 90 days plus the snowstorm. Why would the legislature want to do that?
I'm not sure what the purpose, I can't say that it served any specific purpose, except that the legislature has said that you should be held for a certain number of days, and has said that there can be continuances for the purpose of the defense, for the purpose of the Commonwealth, or due to natural circumstances, and they did not include that, I don't think, in their calculation.
In this case, there are two grounds for detention, right? There's 58A and 58B.
Yes.
Is your answer the same if, and I know under 58B, you have to do it on first appearance. That's the point of it. But if they didn't do it on first appearance, is your answer the same if there was no independent grounds for detention?
If there are no,
There wasn't a 58A in this case?
yes, I think my answer would be the same. It's simply is laid out that way by the legislature
Okay.
in the statute.
Any other questions?
Nope.
Thank you.
Thank you.
Attorney Levin.
Attorney Levin, so that was my question, as far as the alternate grounds of detention that are in this case, and, so the clock, the 58A started at arraignment, and then they start the 58B 6 days later. If we rule in the Commonwealth's favor, does it basically say, no matter what, the 58B is going to start whenever that imposition happens, whenever the judge gets around to imposing it, and if they're even held on bail, the 90 days doesn't start?
Yes, Your Honor. So, for the record, Patrick Levin, on behalf of Cheyenne Velasquez, I think the Commonwealth's position is that neither the 58A nor the 58B days start until the hearing happens. So he's held in limbo right up until that dangerousness hearing. And, I know this is a moot case. It presents an abstract question of statutory construction. And I do think that my reading.
Well, 6 days is 6 days, and it's significant to someone that's being held for 6 days.
Well, that's what I was just going to say, is that, before I really launch into this abstract question, I do want to focus on what's concretely at stake, which is that the Commonwealth says that Mr. Velasquez, who is presumptively innocent of all these charges, has to sit in jail for an extra 4 days before he's entitled to be tried or admitted to bail in the Middlesex Superior Court because a snowstorm delayed a judge of the Lynn District Court in making a finding about his dangerousness on an arraignment in a totally separate case. And to me, that doesn't make sense, and it doesn't make sense to say that probably is what the legislature intended. And so when you go back and look at the statutory language, I don't think, even setting aside this issue of what does the word subsection mean in a statute that doesn't have any, I don't think that the Commonwealth's reading is the best reading of this language. That if you look at it, what it says is that a defendant who's detained under this subsection shall be brought to trial as soon as reasonably possible. But in the absence of good cause, a person so held shall not be detained for a period exceeding 90 days, excluding any excludable delay under Rule 36. Now, what that statute does not say in so many words is what the Commonwealth is saying, which is a person shall not be detained pursuant to this subsection for a period greater than 90 days. What it says is the person who ultimately is detained under this subsection shall not be detained for a period greater than 90 days. And so Justice Nyman recognized that once you hit May 3rd in this case, that's his 90th day. If he's still sitting in jail on May 4th, he has been detained for a period greater than 90 days, which is what the statute forbids. And I do think the Commonwealth is right that this sentence has to mean the same thing in both statutes. And so it would be a permissible construction of this statutory language in Section 58A to have it mean what the Commonwealth is suggesting. But it certainly, as I've just laid out, is not the only permissible construction, and it doesn't make any sense in the context of Section 58B linguistically. And so what I would suggest is the court needs to adopt a reading of this identical statutory language that makes sense both places that it appears linguistically.
I know I should be able to pronounce Mushwalakba, but I can't.
There were some missing apostrophes in the docket. It's
But
mush.
I bet you can.
It's
So-
Mushwa al Akbar.
Yeah, well, thank you. But isn't the whole point of the case that if you're going to have a preventative detention statute be constitutional, it sort of has to be fair, short-lived, and recognize what Justice Georges was talking about, the cost of being detained, never mind preventively detained. So does that case speak to this?
Well, I mean, it doesn't speak directly to this, but I do think that the statement in that case that pretrial detention is constitutional precisely because it is so strictly limited, which that goes all the way back through Mendoza and AIM in this court to ultimately United States versus Salerno. And that's the only thing that makes this statute constitutional. And of course, the legislature, when they enact sections 58A and 58B, are well aware of this because it's right on the heels of the AIM decision that struck down their first attempt to create a preventive detention scheme. And so the language that we're looking at, if you go back and sort of look through the history of the different proposals from the governor on this issue, there's one in 1992 that doesn't contain this language. Then the legislature rejects the governor's proposal, which is modeled on the Federal Act, enacts the amendments to Section 58 that are at issue in Commonwealth versus AIM, or it's AIM versus Commonwealth actually. That is deemed unconstitutional by this court. And some of the concerns relate to the potential length of the detention that is authorized. And then the governor proposes a new bill that has this time-limiting language in it, which ultimately is adopted by the legislature. And I think that, the purpose of this language is to address that constitutional concern and to strictly limit the maximum total length of pretrial detention that's authorized under statute. And so the court, when it's trying to effectuate the legislative intent, needs to read the language with that in mind and say, this is a statute in derogation of liberty. It's got to be strictly construed. And the purpose of the legislature in enacting the particular clause at issue here is to have a strict limit on the maximum length of pretrial detention. And I don't think it makes sense to say that certain days, although a defendant and a presumptively innocent defendant was detained pre-trial, don't count toward his period of pretrial detention. That doesn't make any sense to me at all.
Well, along those lines, it's not really, I'm not saying you have to get to the rule of lenity, but it's not really the rule of lenity. It's that it's substantive due process, that the whole constitutional scheme that you just laid out from Salerno on requires for it to be constitutional, the substantive due process, that it be limited.
Yes, and I'm not suggesting that if the legislature had enacted a statute that clearly said what the Commonwealth is saying that the statute does say, that would not necessarily be the straw that breaks the camel's back in terms of rendering the entire scheme unconstitutional. That's not what I'm saying. But I do think it's vital for the court to read all of the statutory language in light of these constitutional concerns, which the legislature plainly was aware of at the time of the enactment. I don't have a whole lot else necessarily to say about this issue, so unless there are more questions from the court, I would rest on my brief.